Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. When someone who's been injured in an accident and an insurance company, or maybe as a defendant directly if there is no insurance company, but when they decide that they want to resolve a claim, typically there's a lot of back and forth about a dollar amount. But most lay people or non-lawyers don't probably think a lot about what the insurance company or the defendant wants in return for their money. Any astute defendant or insurance company is going to insist upon some sort of agreement from the injured person that they're not going to try to come back against the defendant or insurance company for more money later. And typically this agreement not to come back or to continue a claim against the defendant is called a general release. So I thought I would take a moment in this video to discuss what a general release is and some things to think about before you sign one. First of all, it's important to know that a general release is a binding contract, and essentially the most important terms of this contract is that in exchange for money, the person who signs the release is agreeing to drop any and all claims both now and in the future. Along those lines, part of almost every general release in a personal injury case will have some sort of language indicating that the person who's signing the release understands that their injuries might get worse and they might get better or they might stay the same, but they're resolving the case or agreeing to resolve the case based on the understanding that anything can happen in the future. Practically every release is also going to contain language that indicates that the defendant is not admitting fault in any way. So if you're particularly concerned about someone accepting responsibility or saying that they were wrong or saying that they were sorry, then most general releases are not going to contain any language that's even close to that. These days, most releases will also contain language that put the onus on the plaintiff or the injured person to make sure that all the medical expenses in the case get paid and all the liens in the case get paid. And that's important because in a lot of cases where lay persons or lay people handle their own cases, they don't even know what liens are or how liens might someday affect them. And lastly, although most general releases are kind of standard forms, there is some ability to negotiate. So there may be terms included in a release that you can get some wiggle room on or make some changes to. But typically, a general release is a pretty standard document, and an insurance company or defendant is not going to agree to a whole bunch of changes. It's important to know that courts favor cases settling or cases resolving. So if you sign a general release, it's very likely that a court will enforce it or declare it to be a binding contract. It's very, very, very difficult to get out of a general release once signed. So the moral to the story is don't sign a general release unless you are absolutely sure that you want to and that you understand all of the terms of the general release and that you're willing to accept the money that they're offering you as a full and final settlement of your case. If you have any questions about a Florida personal injury case or general release in any fashion, reach out to us. We love to answer questions. You can contact us by calling our office at 407-254-4901. You can text us at 407-644-4444, or you can even contact us through the Facebook app.